You have the right to be represented by an attorney at this hearing, and you do have counsel present today. You have the right to receive written notice of the charges of violation. Did you receive written notice, sir?
Yes.
Okay. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, sir?
Yes, ma'am. I tried to speak to the public defender that he won't let me talk on the phone to give him evidence that I have against myself.
Okay.
Would you like a continuance, sir? Would you like a continuance for you to, I called your counselor, who was attempting to try to set up another telephone call.
You hung up the phone on me.
No, I didn't hang up the phone, sir. I believe it was the other way around. But like I said, if you'd like a continuance of this hearing for us to talk again, you're more than entitled to that, sir. Would you like a continuance to continue this hearing?
Yes.
Okay.
Okay. So I can continue this case. Let me just look at my calendar.
Come on, bro. Dude, gonna sit up here and say what you know what you did, bro. You hung up the phone on me.
Sir,
Because you did not want to listen to what I have to say.
Listen. Hey,
Just like you doing now.
Mr. Perry,
People, bro. Like,
Mr. Perry, hold on. So I think it would be best to do a continuance, try to have another phone call and get this figured out. It sounds like Mr. Perry has evidence that he wants to give.
Miss, I wrote y'all a letter.
You wrote
about
the board of pardons and paroles of a letter?
Yes, about the public defender. He hung up on me, ma'am. I wanted somebody else to represent me. I have a paid lawyer now that will represent me in this case.
Okay.
Oh, okay. So do you want...
What's your paid lawyer's last name, sir?
Man, I wrote it to them. I don't got nothing to say to you, sir.
So you don't wish to be represented by our office?
No.
Okay, thank you very much.
All right. So can you just send over a withdrawal?
We'll send a withdrawal.
Yeah.
Get me the fuck up out of here. Yo, man, get me out of here, bro. Because I have to sit on things.
Yo,
Man,
calm down. We're not doing that right here.
Oh, yeah, bro. Yeah, bro. This is my life, bro.
All right. So I'm going to continue.
You are trash.
This hearing until the 19th, and I will try and figure out who Mr. Perry's private attorney is. And hold on one second. So I'm going to try and figure out who Mr. Perry's private attorney is. So I'm going to continue this case until March 19th, and I will receive a withdrawal from Attorney Famiglia as well. All right, this concludes the preliminary hearing for Brian Perry, number 373-781. Thank you, officer.
Well, we are going to fast forward to March 19th for him to have this preliminary revocation hearing with his attorney. And I got to tell you, little does he know, but that attorney, he's a public defender, but he is a beast, as in he is the best public defender I have ever seen. Maybe you know who I'm talking about, Mr. Pelmelny, if I'm pronouncing his name correctly.
Everybody has a terrible time trying to pronounce his name. How do you spell that again? I'm like family and Getty. Family and Getty.
Helpful. Family.
Right.
Absolutely. Go ahead,
And
He fights for his clients with the ferociousness and dedication that is impressive. So little does he know that he just threw away probably his best chance at maybe getting away with this. And it just goes to show, if there's any type of lesson to be learned here, you know, don't bite the hand that feeds you. He did. And we'll see if he has an attorney that actually is here to represent him, or if he's going to be here on his own. I don't know. We also are going to catch a hot mic moment that I'll leave on for you right here at the beginning. With that, let's jump in. And that was Mandoo from the past. Some of you might have seen this hearing, and the only reason I'm bringing it back is because he keeps coming back. This is a parole revocation saga that spans over the course of a year. We have 12 months of revocation hearings. So I just wanted to give you that insight. Also, what I wanted to give you is that he's initially locked up. He was charged with attempted murder. He carjacked someone, pulled out the gun, and pulled the trigger, but the bullet never fired. Charged with attempted murder, and he got a gift of a plea deal that only had him serving, I don't know, a handful of years, and now he keeps getting revoked. He can't take advantage of that gift. So yeah, he only ended up getting robbery first degree 9 years, and he was paroled, I think, 4 years after his sentence. But let's watch a clip of the newsreel of that, and then we'll jump in to continue his revocation hearing.
I would ask for mental health attention on the NIT.
23-year-old Brian Perry of Meriden is charged with attempted murder because police say during a carjacking yesterday morning on Martin Street in Hartford, he put a gun to the victim's chest and tried to shoot him.
I needed to see the young man that actually pulled that trigger on my.
Okay. But charges set me up with a person that I just had a fight with. Oh shit. We both just got out the box. You see what I'm trying? That's the third day I did that to me, bro. Not even you, man. It's not even good.
No, that's some fucked up shit, man. Yeah, right. It's not supposed to be around at all.
Good afternoon, Mr. Perry.
Good afternoon. How you doing?
Good, how are you?
I'm all right. Yourself?
All right, so I have you scheduled for a preliminary hearing. We did meet 2 weeks ago and we continued it for today. So I just wanted to check to see if you're ready to move forward today, or if you were getting like private attorney, or what your plan was.
No, we can move forward today. I was put in a little situation where I passed the deadline, you know what I'm saying, what that the attorney gave me, but I'm willing to move forward.
You want to move forward today?
Yes, ma'am.
Okay, sounds good. All right, good afternoon. My name is Parole Officer Michelizzi. I'm a hearing examiner for the Board of Pardons and Paroles. Today is March 19th, 2024. This is a preliminary hearing for Brian Perry, number 373781. And I am at Hartford Correctional Facility via video at Board of Pardons and Paroles. So can you state your name and inmate number for the record?
Brian Perry, 373781.
All right, thank you. This is a preliminary hearing which has three purposes under Connecticut law: to determine if there's probable cause to believe that you commit an act that violated the conditions of your parole, to determine if the act is sufficiently serious enough to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there's probable cause to believe that you violated one or more conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious enough to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you, and this hearing is being recorded. So you have important rights at this hearing, which I will now review with you. You have the right to be represented by an attorney at this hearing. You may hire your own attorney, or if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel today or proceed without counsel, sir?
Proceed without counsel.
Okay. You have the right to receive written notice of the charges of violation. Did you receive written notice?
Yes, ma'am.
Okay. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. And at this hearing, you have the right to call and examine voluntary witnesses as well as cross-examine adverse witnesses. Do you understand these rights, sir?
Yes, ma'am.
Okay, I'm going to place you under oath. Can you please raise your right hand? You solemnly swear and solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, to help you God, or under penalty of perjury.
Yes, ma'am.
All right, thank you. So I'm going to review the charges that your parole officer is charging you with. Charge number 1, condition of release direction under subcategory of GPS. Your parole officer reported that on 3/27/23, you read, initialed, and signed your GPS agreement indicating you understood all conditions. On 10/6/23, you allowed your GPS to shut down from 2:01 p.m. until 10/7/23 at 12:57 a.m. On 10/11/23, you allowed your GPS to shut down from 2:40 p.m. until 3:15 p.m. On 10/25/23, from 1:03 p.m. until 6:09 p.m. And on 10/28/23, from 2:52 p.m. until 9:09 p.m. On 10/21/23, you left the state of Connecticut and traveled to Rhode Island. You did not return to the state of Connecticut until 5 a.m. on 10/23/23. You did not have permission to leave the state of Connecticut from parole, nor permission for curfew extensions. On 12/21/23, you did not stay at your parole approved address and instead you stayed at 1450 Main Street in Hartford, Connecticut. On 12/23/23, you did not return to your parole approved address until 10:30 p.m. Excuse me. You were 1.5 hours late for your 9 p.m. curfew. On the following dates and times, you allowed your GPS to shut down. 12/22/23, from 12:27 a.m. to 4:18 a.m. 12:30, from 1:32 p.m. until 4:34, and again from 11:37 p.m. until 1:44 a.m. on 12/31/23, and on 1/3/23 from 1:04 a.m. until 6:54 a.m. On 1/5/24, you were late for your 9 p.m. curfew again. Your GPS places you on Union Place in Hartford until 11:55 p.m. and you then travel to 1450 Main Street, where you remained for 20 minutes. You did not arrive to your approved residence until 12:23 a.m. on 1/6/24. On 1/10/24, you allowed your GPS to shut down from 4:32 p.m. until 4:35 p.m. On 1/19/24, you allowed your GPS to shut down from 11:17 p.m. until 3:24 a.m. on 1/20/24. On 1/25/24, you allowed your GPS to shut down from 4:47 p.m. until 10:55 a.m. on 1/26/24. On 2/2/24, you allowed your GPS to shut down from 6 a.m. until 4:47 p.m. On 2/3/24, you did not stay at your approved residence. Your GPS points placed you at the Econo Lodge in East Hartford. You did not have permission to stay out on any date. Charge under curfew. Your parole officer reported that on 10/21/23, you left the state of Connecticut and traveled to Rhode Island. You did not return to the state of Connecticut until 5 a.m. on 10/23/23. You did not have permission to leave the state of Connecticut from parole or no permission for a curfew extension. On 12/21/23, you did not stay at your parole approved address. Instead, you stayed at 1450. On 12/23/23, you did not return to your parole approved address until 10:30 p.m. You were 1.5 hours late for your 9 p.m. curfew. On 1/5/24, you were late for your 9 p.m. curfew again. Your GPS places you at Union Place in Hartford until 11:55 p.m. and then you travel to 20 minutes. You did not arrive at your parole approved residence until 12:23 a.m. on 1/6/24. On 2/3/24, you did not stay at your approved residence. Your GPS places you at Econo Lodge in East Hartford. You did not have permission to stay out on any date. Charge number 2 of obey all laws under obedience to the law. Your parole officer reported that on 2/20/24, you were observed by East Hartford PD operating a Honda Accord LX with an expired marker plate that belongs to a black color 2008 Acura MDX sport utility vehicle. When East Hartford PD attempted to pull you over by activating their lights and sirens, you continued to drive until you reached the parking lot in which you reside on Hillside Street. Once in the parking lot, the passenger inside your vehicle was observed exiting and running. Police engaged in a pursuit after the passenger that ran. When officers checked the car, you were seen operating. You were no longer inside. However, police did locate your cell phone and wallet that had your identification on it. The vehicle was later called in by the owner and reported stolen to East Hartford PD. While police were at the residence of the victim, you reported the vehicle stolen. The victim who reported the vehicle stolen, you walked in and said the vehicle was not registered and should not have marker plates on it. You stated you did not know how the vehicle had your cell phone and wallet in it. The police were able to pull camera footage off off their building surveillance that showed you operating the motor vehicle at the time of the incident. Police went back to your residence at 50 Hillside Street, apartment C, and the victim called you out to the hallway. You were subsequently arrested by East Hartford PD and charged in violation of interfering with police, misuse of place, disobeying the signal of an officer, operating an unregistered motor vehicle, and operating a motor vehicle without a driver's license. You were arraigned at Manchester Court on 2/21/24 and held on a $5,000 bond. A remand to custody was lodged by parole. Charge number 4 under travel. Your PO reported that on 10/21/23, you left the state of Connecticut and traveled to Rhode Island. You did not return to the state of Connecticut until 5 a.m. on 10/23/23. You did not have permission to leave the state of Connecticut from parole, nor permission for curfew extension. On 1/27/24, you left the state of Connecticut without parole's permission. You traveled to the state of Massachusetts on that date after this officer informed you that you did not have permission to leave the state of Connecticut. All right, so those are your charges. I do have evidence from the state. Exhibit A is conditions of parole. B is a remand to custody. C, parole violation notice. D is a parole violation report. E, Allied Universal GPS reports. F, offender misconduct. G is East Hartford police report. H, GPS monitoring agreement. I, picture of Brian Perry driving on 2/20/24. J, Board of Pardons and Parole's revocation hearing summary. All right, so that's what I have from parole. I do not have a parole officer here to offer any additional evidence at this time. So is there anything that you would like to say regarding those charges that I just read?
For the Massachusetts, I was, which was on a Saturday that I had went. I didn't get my new parole officer until that Monday, which I got permission from my old parole officer, which was Holiday, to go because I was playing semi-pro out of Massachusetts for the New England Bulldogs. The only thing that I did not have permission for was Rhode Island, and in my cell phone I have permission for 11 all the way up to January 4th to find a new residence due to an altercation that me and my girlfriend was dealing with at the time. And when the police came to my crib, that was not my girlfriend who they was questioning. That was my 15-year-old daughter, which is why I got the interfering with the officer.
You are trash.
All right, anything else?
No, ma'am.
Okay. So charge number 1, condition of release direction under GPS. I am making a finding of probable cause based on the evidence provided by the state, specifically the Allied Universal GPS reports and also the GPS monitoring agreement. Charge number 2 under curfew. Same thing. I am making a finding of probable cause based on evidence provided by the state, specifically those GPS points and the GPS agreement from parole. Charge number 2 under obey all laws, obedience to the law. All right, so this is for the arrest on 2/20/24. I am making a finding of probable cause based on evidence provided by the state, specifically the police report that was provided as evidence. In charge number 3 of travel, I am making a finding of finding of probable cause based on evidence provided by the state, specifically those GPS points, as well as the parole violation report. All right, so I have, it looks like you were out on parole for about a year. You have 1 criminal violation. You have several noted misconducts. I think all the misconducts that were noted as in the parole violation report that you've also been charged with them on the charges as well. All right. And you do have that criminal case pending. So I did make a finding and I have determined that it's serious enough to warrant revocation and continue incarceration. So I will see you again once those cases get disposed of. I will see you again and we will talk about if you violated those parole conditions and what, if any, sanctions should be imposed at that time, okay? So once that criminal case gets disposed of, I'll see you again, okay?
Or,
Do you have any questions?
Yes.
Yeah, sure.
Can I use my phone as evidence for everything that you saying on everything that I got violated for at my parole, my revocation hearing?
Yeah, what do you mean? So you want to use your phone as evidence? Is there like, what do you mean, text messages?
Everything that y'all say, listen, I'm not trying to come in here or everything that was displayed on that paper right there, I have permission for. But it just
so if you have
the officer,
go ahead.
the cop, oh my bad, the cop has my cell phone in holding. They never put it in my property so that it wasn't able for somebody to obtain it. I have messages from parole officer from the beginning all the way to the end on everything that I was violated for. Even when I went to Rhode Island, it was notified to the parole officer that I was going to Rhode Island, and she allowed it and just brought me back in and changed my 12 o'clock curfew to 9 o'clock curfew.
Okay. So if you have evidence on your cell phone of what we talked about today, like the report, the charges that we talked about, you can bring that as evidence, but you're going to need someone to be able to like print stuff off the phone or like get the phone. It's something like that. Do you know what I mean?
Yes.
So if you
that's what I was.
Yeah, if you have something like that, you can send it to me at my office, or you can fax it over, you can email it over, whatever works.
Yes, ma'am. Okay.
You can absolutely do that for your revocation hearing. Get all the stuff you can and submit it. Absolutely.
All right.
Okay?
Yes, ma'am.
All right. So I will see you again once that case gets disposed of. But in the meantime, I would work on getting some of that evidence that you have, okay?
Yes, ma'am.
All right. So this concludes the preliminary hearing for Brian Perry, number 373781. All right, I'll see you again, okay?
All right.
All right, good luck.
Okay, and now we're going to fast forward to September after those cases, I don't know, were disposed of to watch the continuation of his revocation hearing. So just as a brief reminder, March 5th, 2024 was his initial revocation hearing. 2 weeks later, we have the hearing which we saw after he fired his attorney, and now we're fast forwarding to Tuesday, so from March 19th to Tuesday 10th, 2024 to continue the hearing. And this is something interesting that I want to point out, and thank you, Lady Holly, for putting in the facts, just so we can get a little bit more context. He's initially sentenced for really he was charged with attempted murder when he carjacked a man and shot, but the bullet didn't fire. He was given, let me just scroll through this for you so that you can have some context here. He was given the 9-year sentence with special parole 6. Now, in 2019, he had a sentence modification, so a gift. First, so he gets from attempted murder to just first-degree robbery, which is a gift. Then, 4 years into that sentence, in 2019, he gets another gift. They drop it to 5 years special parole 6. So he gets out. And it seems that he does okay for a couple of years, supposedly. Oftentimes we don't see, but then he picks up these new charges, which breach of peace, but this isn't even what we just heard about, which is where he had 2024 where he was driving a stolen car, right? And now he has the revocation hearing. And it's really crazy when you see this. This is just what we see, the merry-go-round of Connecticut parole revocation hearings. And what happens is, in my opinion, I believe what's happening is the DAs, they don't want to go through the whole courts and charge in the this and that. They know that the guy's on special parole, so they just drop the charges and let parole handle it. But then we can see how parole handles it. And in my opinion, it seems almost like a get out of jail free card, like a backdoor I'm on special parole. I can go and catch new felonies, but the police will just let it go. That's how I'm interpreting it. I could be wrong. Maybe it depends on the situation. But anyways, let's jump into this hearing. And I'm happy to tell you that he made nice with his attorney because he's back. So let's go.
Solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God, or upon penalty of perjury.
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of your conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review that evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
On December 23rd, 2023, you did not return to your parole-approved address until 10:30 p.m. You were an hour and a half late for your 9 p.m. curfew. On January 5th, 2024, you were late for your 9 p.m. curfew again. Your GPS places you on Union Place in Hartford until 11:55 p.m. and then you traveled to on charge 3, obey all laws. On February 20th, 2024, you were observed by East Hartford PD operating a Honda Accord LX with an expired marker plate that belongs to a black colored 2008 Acura MDX sport utility vehicle. When East Hartford Police Department attempted to pull you over by activating your lights and sirens, you continued to drive until you reached the parking lot in which you reside on Hillside Street. Once in the parking lot, the passenger inside your vehicle was observed exiting and running. Police engaged in a pursuit after the passenger that ran. When officers checked the car you were seen operating, you were no longer inside. However, police did locate your cell phone and wallet that had your identification inside of it. The vehicle was later called in by the owner and reported stolen to East Hartford PD. While police were at the residence of the victim who reported the vehicle stolen, you walked in and stated the vehicle was not registered and should not have marker plates on it. You stated you did not know the vehicle had your cell phone, how the vehicle had your cell phone and wallet in it. The police were able to pull camera footage off their building surveillance that showed you operating the motor vehicle at the time of the incident. Police went back to your residence at 50 Hillside Street, apartment C, and the victim called you out to the hallway. You were subsequently arrested by East Hartford Police and charged in a violation of Connecticut General Statute 53A 167A, interfering with police, misuse of plate, disobeying signal of an officer, operating an unregistered motor vehicle, and operating a motor vehicle without a driver's license. You were arraigned at Manchester Court on February 21st, 2024, and held on a $5,000 bond. A remand to custody order was lodged by parole. On charge 4, travel. On October 21st, 2023, you left the state of Connecticut and traveled to Rhode Island. You did not return to the state of Connecticut until 5 a.m. on October 23rd, 2023. You did not have permission to leave the state of Connecticut from parole, nor permission for a curfew extension. On January 27th, 2024, you left the state of Connecticut without parole's permission. You traveled to the state of Massachusetts on that day after this parole officer informed you that you did not have permission to leave the state of Connecticut. The state has filed the following exhibits. Exhibit A, Statement of Understanding and Agreement, Conditions of Parole. Exhibit B, Remand to Custody Order. Exhibit C, Parole Violation Report. Exhibit D, Parole Violation Report. Exhibit C was Parole Violation Notice. Exhibit E, Allied Universal GPS Reports. Exhibit F, Offender Misconducts. Exhibit G, East Hartford Police Report. Exhibit H, GPS Monitoring Agreement. Exhibit I, Picture of Brian Perry driving on February 20th, 2024. And Exhibit J, Board of Partisan Parole Revocation Hearing Summary. The state filed an addendum to Exhibit D, which states on July 25th, 2024, Mr. Perry pled guilty to interfering and resisting arrest. He was sentenced to 30 days jail, and the following charges were dismissed: misuse of plate, disobeying the signal of an officer, operating an unregistered motor vehicle, and operating a motor vehicle without a driver's license. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, we have.
Defense has filed the following exhibits. Exhibit 1, parole accomplishments and future plans for parole reinstatement. Exhibit 2, employer letter. Exhibit 3, letter of reference from girlfriend. And Exhibit 4, letter of reference from head coach from New England Bulldogs. Today, we have no witnesses. It is now the defense opportunity to present evidence and speak to any of the evidence submitted.
I have no comment as to the preponderance standard as to charge 1 or charge 2. However, as to charge 3, the only charge that he pled guilty to was the interfering, so I only ask that a finding be made as to that. He served the 30 days. And as to charge 4, travel, one of the elements regarding part 2, the travel to Massachusetts, one of the elements of travel is that he was not traveling for work. He actually was traveling to Massachusetts for his work as a semi-pro football player. He states he was monitored for the first 7 months without misconduct by, I believe, parole officer Howland. And then the last 3 weeks before the arrest, he wasn't violated prior to that for any of this prior stuff. He was, I believe, Langon was his, pardon me if I'm mispronouncing it, was his PO. And my client claims that he had a permission and an understanding with his PO that he could travel to Massachusetts to work as a semi-pro football player. So that would be my comment about the preponderance standard for charge 4. Thank you very much. The team is based in Springfield, Massachusetts, and they have practices as well as games.
I'm looking at the elements here. Attorney Flamighetti says Parole left the state of Connecticut and he left the state of Connecticut without prior written permission. I don't see anything about work.
I believe there is an exception that you can leave for work under travel.
Hey, it's Officer Bennick. I'm listening to you guys. Am I allowed to talk or no?
No, unfortunately, no, you're not. You're not his PO, correct?
I'm not. They need a travel pass for work. So I wasn't sure if I could let you know that or not, but I'll butt out.
Thank you.
Bye.
On charge 1, GPS, I make a no finding on the following dates: October 11th, 2023, October 28th, 2023, and December 23, 2023. The state failed to provide sufficient evidence to prove Mr. Perry's action meets the elements of this charge. I make a finding on the rest of the parts listed in this charge based on state's exhibits A, C, E, F, and H. On charge 2, curfew, I make a no finding on the date December 23rd, 2023, as the state failed to provide sufficient evidence to prove Mr. Perry's action meets the elements of this charge. I make a finding on the rest of the parts of this charge listed based on state's exhibits A, C, E, F, and H. On charge 3, obedience to the law, I make a no finding on the charges of operation of an unregistered motor vehicle, disobeying a signal of an officer, misuse of plate, and operation of a motor vehicle without a license. As these charges are considered infractions and not crimes, I make a finding on the rest of this charge based on state's exhibits A, C, and G. On charge 4, travel, I make a finding based on state's exhibits A, C, E, F, and H. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, as I stated earlier, my client did very well without any issues whatsoever for 7 months. And then I asked myself, well, what changed? And I think it was a misunderstanding about whether or not he could leave and go to his practices. I believe that explains some of the GPS and curfew violations. I believe it explains his travel to Massachusetts. This was a minor motor vehicle incident where he only received 30 days. He served that time. My client's been incarcerated now since February 20th for 7 months for this. He has a letter of support from his employer that's a very good letter of support, speaking to that he's a quick learner. As a concrete mason, he's always on time. He would stay late with me to finish projects. He has a job waiting for him when he comes home with construction. I also would ask you to look at the points expressed by Andro. He worked with her autistic son to further develop his speech, other activities daily. He was preparing to coach her football team, her son's football team. And I think it's consistent also in the letter from the coach that my client's actively trying to teach children a better way by using physical activity. He has in the community also become involved in the football community, pulling at-risk youth off the street from gun violence and teaching them how to be involved in football. He has provided food and clothing to those in need. He started a co-ed flag football league in his community and also was working with the Board of Education to start a quote-unquote Month of Madness basketball tournament for high school students. He wishes to be sponsored by his significant other again, who he was sponsored by in the past, Miss Del Sandro in Hartford. He had started a barbering program. He wishes to go back to that, and also he can return to Latimer Concrete. He has 4 children. He receives support from his mother, Ms. Davis, his father, 6 sisters, and his significant other, his children's mother, and his boss. He was enrolled, as I stated, at Academy di Capelli for barbering. He's worked in the past at FHI, FedEx, and was reportedly hired at Amazon and also as a cook at a local hotel. All violations of parole are arguably serious. I don't believe any of these violations are so serious to require more than 7 months of incarceration. He wasn't violent towards anyone. He has a good foothold in the community. I think the recommendation of 12 months is a bit draconian. I think it's a bit lengthy that the PO made. I'm not sure why. I don't think him sitting in jail for 5 additional months is going to teach him any lessons. I don't think it's going to protect the community anymore. I think it will delay his reintegration and his ability to give back to the community. Thank you for your time and consideration.
Thank you. I recommend reroll and reparole on September 19th, 2024, which is an approximate 7-month sanction. I recommend the following conditions: no consumption of alcohol, anger management, no contact with co-defendant Paula Brown and Nikon artist, no contact with victim MW, mental health treatment, no operation of a motor vehicle without the express permission of your parole officer, and a halfway house placement in the event that it is needed. My findings and recommendations be forwarded to the board. You will receive official written notice from the board, and your board review is scheduled on September 19th, 2024. The board may let my recommended sanction stand or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before that hearing, the board will provide you with specific reasons documenting why they would want to exceed my recommendation. During the supplemental hearing, you would have an opportunity to respond to those specific reasons while in front of the panel of the board. This concludes the revocation hearing.
Okay, so Mr. Perry, this is the shortest possible sanction that she could have given you. So that's a good result. We have to wait and see what the board says on the 19th. If they agree, you'll be released on September 19th. If they don't agree, call me the next day and we'll tell you when they're going to be released. Okay?
Okay.
Good luck, sir.
Thank you.
Thank you.
You're welcome.
Well, it was good for him that he made nice with his attorney, because his attorney got him out just 9 days after that approach. But too bad for him, he's not been able to stay out of trouble, because he is back January 7, 2025, and he is back sitting in that chair facing revocation again. To give you a little bit of update again, or just a summary of what happened, he was revoked. He had his preliminary hearing March 5th, 2024. He fired his attorney. He came back March 19th, 2024, alone, without his attorney. They said, hey, we got to wait.
Good morning, sir. What is your name?
Brian Perry.
Okay, give me a moment. I'm going to connect with your PO and you don't have an attorney. So I'm going to connect with your parole officer, okay? Thank you.
Yes, ma'am. All right.
Wait until the police settle the charges against you. They did. They ended up giving him just like a 30-day sentence. We saw him again September 10th, 2024. He had made nice with his attorney. His attorney was back, and they re-released him September 29th, 2024. And now we're back January 7th, 2025, and we're going to see what it was this time. And I just want to get a few things off my chest before we jump into this. One is that did come out of right field that he plays for 2 semi-pro college football teams. I did look them up. They're on YouTube. They look pretty good. I tried finding a play with him in it. I couldn't find anything. I tried finding a roster to see what position he is. Maybe he's like a running back. He's kind of small, right, for a football player. But isn't it? I always find it fascinating. The difference between it's a AAA team. You know, the difference between being semi-pro and pro can be such a small difference, and your whole life can be so different. And but what I can't get over, and of course this is just crazy. You hear the oh he coaches my son, and oh he works with the youth, and oh he works with the a co-ed flag football team, and all these things. And it's like, do these parents know that this man who literally pulled a gun on someone and pulled the trigger, who seems to be clearly unstable, who is dangerous I mean, come on, look at his record, is involved in the youth? That seems so scary. And I think it's, the difference between getting an attempted murder charge and then not, it's pretty nuts, right? So let's go. Before we go in, let me just share with you Lady Holly's random fact of the day. She puts it in the spreadsheet. And this one is, in Louisiana, it's illegal to send a surprise pizza. Who would have thought? Isn't that interesting? Why? Where? At what point? It just makes me want to ask ChatGPT. We're not going to go on a tangent. We're not going to do that. But like, remember, legislation has to be written into law. Like, the legislators have to come together and say, we are going to pass a law where you cannot order someone else pizza. And I'm sure there's a good reason for it, but it is kind of fascinating to me. Anyways, let's jump in and see what happens.
Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or on penalty of perjury?
I do.
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charge that the state Bureau parole officers bring against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney if you cannot afford an attorney. And if you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without counsel?
Proceed without counsel.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state Bureau parole officers bring against you and the information underlying each charge.
Yes. As far as charge number one with the GPS, Mr. Perry had the Allied Universal GPS monitoring device on his ankle, which showed that on the 3 days, January 6th, January 7th, and January 9th, that he was not where he was authorized to be on those dates. And we have the monitoring reports that back that up. And as far as charge number two in the halfway house placement, he was at 2 different halfway houses over a 30-day period where he left the halfway house without authorization and was unaccountable in the community.
Thank you. Anything further?
Well, I guess what I would say is that there are case notes, the interactions that are part of the evidence that just show that I think Mr. Perry was having a very difficult time with parole, and when the conditions of parole and some of the parameters that were set on him. And I think in some of these cases, his anger had gotten the best of him, and were a detriment to him being successful on parole, despite parole trying their best to get him to have a successful time on parole.
Thank you. Mr. Perry, it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
Yes, ma'am.
Go ahead.
I agree with Gerard about the anger. A lot of things I didn't really understand. That was like my first time really in a halfway house. So I'm used to dealing with a special parole officer on a one-on-one basis instead of having to wait for certain things. So it's like I didn't understand when they told me about certain restrictions. I didn't understand because when I was in one halfway house, they was allowing me to do certain things. Then when I get to this halfway house, I was supposed to go home, which I felt like when it came to my programs, like CRT, certain things, I don't know if it was I don't know if they got notice of it or whatever. So it was like, I felt like a lot of things was taken from me without explanation. And instead of me really just waiting and sit it out, I allowed my anger to just really get the best of me. I wasn't used to that setting. And I did certain things I did what I felt was best. Like when I walked out, when I was at the Watkinson house, I walked out because I tried to de-escalate the situation the best way I know how, and that was to walk away instead of engaging. And I went to CRT because I knew that it was a program. I had to give a urine. And I just really was kind of confused. When she told me that I was under restrictions, it wasn't like really broken down to me how far my restrictions went.
Anything else?
No, ma'am.
Okay. And Pio Gerard?
Yes, nothing else.
Okay. On charge 1, GPS, I make a no finding of probable cause on part 3, as the state failed to provide sufficient evidence to prove Mr. Perry's action meets the elements of this charge. I make a finding on the rest of the parts listed in this charge based on state's exhibits D, M, O, P, Q, R, U, and AA. On charge 2, halfway house placement, I make a finding of probable cause based on state's exhibits D, E, I, J, L, S, W, and AA, as well as testimony today. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. So, Mr. Perry, your revocation hearing will be scheduled within the 60 business days since you've come back into custody. You will receive a hearing disposition, which will have a tentative hearing date listed, but please keep in mind that all hearing dates are subject to change. At the revocation hearing, a hearing examiner will determine if you violate the conditions of your parole, and if so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanction should be imposed. Okay, so that does conclude your preliminary hearing, and again, you'll receive your hearing disposition with your revocation date, which is again tentative. Okay.
Yes, ma'am.
Any questions?
No, ma'am.
You're all set. Thank you, Mr. Perry.
All right, thank you. Yeah, have a good day.
Thank you, Mr. Perry.
Okay, and he's had to wait quite a long time. He's had to wait from January all the way to January 27, 2025, all the way to April 1st for his official revocation hearing. And hey, it's an April Fool's Day. We're going to see him again. What do you think they're going to do? Again, they can sanction him. They have him under special parole, under their control up until the year. Let me check Holly's sheet over here. Up until 2026, 5/14/2026. So I guess the most that they can actually hold him for is a year. Are they going to do that, or are they going to let him out after another 3 or 4 month sanction? I guess that's what we have riding on this. Is he going to have to sit until 5/14/2026, or Will he get another chance? Let's find out. Today's video is sponsored by Aura. Did you know companies can take months to report a data breach? On average, it's 277 days before you even find out that your personal data has been exposed. Think about that, 277 days. That means that your sensitive information like your email, your phone number, even your financial details can already be out there. Now, it's not just one company, but major banks and corporations, they've all experienced breaches in the past year. Maybe you've seen about it in the news. Your information could be compromised right now and you wouldn't even know it. Now, that's why I use Aura. Aura scans the dark web and alerts me fast if personal information has been leaked. If someone tries to open a bank account or credit card in my name, I'll know right away. I have been using Aura for about maybe 9 months now. Something that they also do that really helps me a lot is keep spam callers away. That's a big bonus for me. They actually remove my name from those spam caller lists. Now, they also provide up to $5 million in identity theft insurance and a full suite of tools to keep you protected. And this is it's all done in one app. You can try Aura for free for 14 days at aura.com/Mandoo. And that's 2 weeks to find out if your data has already been exposed before you hear from a company months later. So why wait? Get some peace of mind and try out Aura for free. Take control of your digital security right now. And now, let's go back to the hearing.
Today is Tuesday, April 1st, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Brian Perry, 373781.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Good morning, Public Defender Robert Famigletti of the Parole Revocation Unit. Hello, sir.
As well as your parole officer.
Hi, Parole Officer Gerard.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Perry and P.O. Gerard, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. P.O. Gerard?
Yes, I do.
Thank you. First, I will read you your rights, and then we will review the parole violation charge that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Both the state as well as your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, the state as well as your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Starting with charge 1 GPS, P.O. Gerard.
Yes, charge 1 GPS. On 1/6/25, you signed out of Stein Halfway House at 4:25 p.m. with an approved return time of 11:45 p.m. Your pass granted you to travel to your place of employment, Chick-fil-A, upon staff conducting an employment verification check, and per your GPS monitoring device, you did not report to work. This is in violation of your GPS agreement that states, I will follow all established curfew, work, and program schedules and must obtain prior permission from a parole officer prior to changing any established schedules. On 1/7/25, you signed out of Stein Halfway House at 3:57 p.m. with an approved return time of 11:45 p.m. Your pass was granted for you to travel to your place of employment, Chick-fil-A, in West Virginia, upon staff conducting an employment verification check, and per your GPS monitoring device, you did not report to work. On 1/9/25, you walked out of Stein Halfway House without authorization. You walked out the door at 1:01 p.m. and did not return back to Stein Halfway House until 3:28 p.m. This is in violation of your GPS agreement that states, I will follow all established curfew, work, and program schedules and must obtain permission from a parole officer prior to changing any established schedules. On 12/11/24 at 9:57 p.m., you exited the front door of Watkinson Halfway House. A staff member followed you to inquire where you were going. You responded, y'all called the effing cops, right? And continued out the gate and off the property. You did not return to Watkinson Halfway House. This is in violation of your statement of understanding and agreement conditions of parole. Specifically, in the event I am placed in a halfway house, I agree to go directly to and reside in the facility designated by Parole and Community Services Division until released by the Parole and Community Services Division. I will abide by the written rules of the facility. I will not leave the physical confines of the facility or the property thereof, except for traveling to and from work or as authorized by facility or Parole and Community Service Division rules. Charge number 3, halfway house placement. On 1/9, you walked out of Stein Halfway House without authorization. You walked out at 1:01 p.m. and came back to Stein at 3:28 p.m. You had communication with your assigned PO during this period, and you were directed to go back to Stein Halfway House. You did not follow that direction. You were unaccountable in the community for 2 hours and 27 minutes. This is in violation This is in violation of your statement of understanding and agreement conditions of parole. Specifically, in the event I am placed in the halfway house, I agree to go directly to and reside in the facility designated by the Parole and Community Services Division until released by the Parole and Community Services Division. I agree to abide by the written rules of the facility. I will not leave the physical confines or the facility or the property thereof, except for traveling to and from work or as authorized by facility or Parole and Community Service Division rules.
The state's exhibits were marked and identified at the preliminary hearing held on January 27th, 2025. The state found an addendum to Exhibit AA, which states on February 13th, 2025, Mr. Perry was served with a warrant by Connecticut State Police at Robinson Correctional Institution. Mr. Perry was charged with assault third. Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
Yes, I did, and there should have been an additional addendum filed because that assault third charge was nollied on March 14th.
Thank you. Theodore, did you file an additional addendum? Because I did not receive that. Did you file one?
I did, yes. I think it was just approved yesterday. I believe the addendum was approved yesterday, and my addendum was just stating that, let me see. The addendum says on 3/17, this PO was informed that subject appeared in GA 14 in court GA 14, and the case for his assault third charge was disposed of and nollied.
Okay, thank you.
So, yeah.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, as well as Defense Exhibit number 2, employment letter from Taekwon Johnson. Today we have no witnesses. At this time, the state will have an opportunity to present evidence to speak to any of the evidence submitted. Pio Gerard?
Well, per the parole violation report that we submitted, we have with his GPS coordinates, we have that he was in fact unaccountable in the community on those 3 occasions that I mentioned where he signed out of the halfway house for work but never reported there. Also, as far as residence goes on with the incident that happened on December 11th, he did in fact walk out and leave the halfway house, and rather than violating him, parole attempted to work with him and place him in a new halfway house, which then ended up being under my supervision. So that's all I have.
Thank you. It is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Yes, as to the preponderance standard, on the January 6th and January 7th dates, he was gone approximately 7 hours, each of those dates. And one of the things that the parole officer read is that you're not allowed to do that without parole permission or without halfway house staff permission. And my client actually had permission from Alicia Brown of the halfway house. What he was doing during that time was he was attempting to acquire a dog for her. And so that's why he had strayed those 2 days in a row to do that. And so our claim is that he was permitted by Alicia Brown to do that. As to charge 2, him being gone for 17 hours on 12/11, he also had permission to do that because that was the date of the incident that the arrest warrant subsequently that was nollied, that subsequently was filed served on him in February. He began leaving, and the parole and one of the halfway house staff asked him, where are you going? What's going on? He goes, I want to just cool down. This just happened. Did you call the police? So they told him it was okay for him to leave the halfway house to cool down for a cool down period to make sure nothing further happened. He did eventually return. And so for those reasons, for charge 1 and charge 2, we believe that the preponderance standard isn't met because he was given permission. Thank you.
Counsel, I just want to clarify, you said that he received permission from Alicia Brown to go obtain a dog?
Yeah. To go look for a dog, correct.
At the halfway house?
No,
she's a staff
personally.
Oh. She's a staff at the halfway house?
Yes.
Thank you.
Pio
Gerard? Yeah, that is, as far as I'm concerned, completely false. This is my first time ever hearing anything like that. Typically whatever is on the pass, that's where he's able to go. Whatever is on his pass, whatever it is that he's been given permission for, that's where he's able to go. So as far as I'm concerned, as far as I know, that's completely false regarding Ms. Brown, who works at the front desk. That's her role. She works at the front desk. And as far as the incident that happened on December 11th, halfway house staff would never allow someone to just walk off the property overnight. I mean, walk off the property in general. That could be broad daylight, but and they wouldn't allow that. That's just not something that's allowed.
Just briefly in response, we completely agree. We completely agree that that's not allowed, but he is allowed with permission of the halfway house. He was only relying on what they said to him. I'm sure it comes as a surprise to the officer. It came as a surprise to me. But we're just claiming that is why he felt it was okay for him to leave. Thank you. And also, that is also why he felt it was okay for him to go and divert from the pass to get the dog. Thank you.
Theo Gerard, anything further?
I mean, the only thing I would ask is there any proof of either of those accusations that at two separate halfway houses, two separate staff members allowed him to be unaccountable in the community?
Just my client's word. And I guess there's just as much proof that he didn't have permission. We're just going by what we're hearing from the halfway house staff. So I guess, and they're not available for cross-examination. They're not available as witnesses. So, you know, I'm just going by what my client has told me. I'm just going that I don't believe that because he had permission, it should be a basis of his violation. That's all. Thank you.
Thank you. Theo Gerard?
Yes, the only thing I could say to that, and I respect everything that you're saying, the only thing I could say to that is that the offender signed misconducts for all of these things, his signature on it, and never once brought any of this to our attention up until this morning.
Thank you. Counsel?
Yep.
I've got nothing further as to the preponderance standard.
Thank you very much. I'm just going to take a moment before I announce my findings. Regarding charge 1 GPS, a no finding was made on part 3 at the preliminary hearing held on January 27th, 2025, and will not be considered as today's revocation hearing. I make a finding on the rest of the parts listed in this charge based on state's exhibits D, M, O, P, Q, R, U, and AA. Regarding charge 2, halfway house placement, I make a finding based on state's exhibits D, E, I, J, L, S, W, and AA. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney as well as the state will have an opportunity to speak to your background and history. Theo Gerard, would you like to make a statement regarding Mr. Perry's background and history?
I would just say that Mr. Perry was under my supervision for a little bit over a month. And during that time, I made every attempt that I could to work with him, talk with him, and get, kind of everything figured out. Like I said, I took over really just at the tail end of his supervision, but based on all the evidence and exhibits that are listed in here, he has shown a pattern of aggression and disrespect toward anyone placed in the position to supervise him. Whether if it was a parole officer, a parole supervisor, anyone. And I know I listed some of the exhibits here, some of the interactions that he had with some of the parole supervisors, with him basically cursing them out and saying all sorts of stuff. And even with me, who I felt like I had a relatively, good rapport with Mr. Perry over the 4 to 5 months that I was supervising him. But during his remand back to custody, he was so aggressive that the other POs said, you know what, Gerard, just we'll deal with him because he clearly has some rage going on and it's directed toward you. And so not only did they do transport bringing him to the facility, but they also took over with serving him as well, because just because we didn't want to trigger him anymore in any sort of way. And for me, it did feel like it kind of came out of nowhere, obviously, with the circumstances of his being remanded back into custody, that usually isn't a good day for anyone, we're in his position, but his aggression and rage, I think kind of throughout the remand, and then his aggression throughout his supervision, just showed a clear pattern of negativity. I think that's all I have. Thank you.
Thank you. Counsel?
Yeah, it's completely unsubstantiated. We have 2 charges here. First, he was out on parole for 3 months, not supervised by this parole officer. with absolutely no problems. None.
None.
From September 19th to December 11th, which is the date that he left, and he says he had permission to leave. So we're talking about leaving and not going where he's supposed to go in his past. That's what this violation is about. It's not about his attitude. It's not about any there's no alleged aggression here in this violation. There's no alleged rage here in this violation. This is all materialized 5 seconds ago. It's no part of this violation. None of the exhibits should go to any rage or anything of that effect because it's not an element of a GPS violation and it's not an element of the halfway house placement for being gone 2 hours and 27 minutes and being gone 17 hours after the incident, which was not legal. There's absolutely no elements, nor is it relevant to the testimony today that someone thinks he has an aggression or rage problem. That's prejudicial. That's an attempt to say that my client was in any way, shape, or form a bad parolee. He wasn't. The only basis here, and these are very minor violations. He's been on parole for 4 months here. And January 6th, 7th, and 9th, he's gone. One of those, there's no finding for the 9th. So the 6th and the 7th, he's gone while he's supposed to be at Chick-fil-A. Okay, didn't commit any new crimes. He wasn't violent. He wasn't aggressive. He was trying to find a dog, if you believe our aspect of it. Otherwise, this is not like he was somewhere else committing a crime or being aggressive, like we're to believe that my client is aggressive. He's a productive member of society. We have a letter, Exhibit 2, from a coworker who helps operate Latimer Concrete. He's been a concrete mason for the company for the last several years. Upon his release, the Department of Parole in Hartford requested information for the company of vehicles. The information was provided to them, but Mr. Perry was still not given permission to work with the company again for no apparent reason. When he's released, he will still have a position with concrete. He's 33 years of age. He has 4 children. He receives support from his mother, father, 6 sisters, his significant other who suffers from multiple sclerosis, his children's mother, and his boss, Anya Latimer. My client enrolled at Academy de Capelli. However, he was unable to begin because he was remanded for these minor violations. He's had a great job in the past several years for Latimer Concrete Forming in Hartford. He did work as a full-time breader at Chick-fil-A while he was in Steinhouse. He's worked in the past at FHI, FedEx. He was hired at Amazon, and he was a cook at a local hospital. He has an excellent work history. He was in a weekly anger management group at community renewal team in the past. He took reasoning and rehabilitation program, participated there twice weekly at CPA. He completed a 5-hour anger management course online. It was a one-on-one course. He was participating back in 2022 in individual psychotherapy, including anger management at Wheeler Clinic. He has in the past, through his football prowess, as he plays for 2 semi-pro professional football teams, one in the summer and one in the fall. Those teams are the Connecticut Lightning in the summer since 2020 and New England Bulldogs in the spring. He helps by pulling at-risk youth off the streets and helping them become involved in football. He wishes to be sponsored by his significant other, Angelina D'Alessandro. He wishes to enter a barbering program at Academy di Capelli, as he had been accepted in the past, but unfortunately was remanded. He can return full-time to Latimer Concrete. Over the past 3 years, I've seen a lot of serious violations. I see a lot of violations for violent reasons, a lot of violations for multiple reasons. Here we have 2 occasions that he was gone for 7 hours. And then another occasion after the Nolly case, after that incident occurred, he cooled down, came back to the halfway house. I'd ask that you release him the soonest possible date. I don't believe any of these violations are sufficiently serious to hold him any further. He's been held since January 10th. Thank you for your time and consideration.
Thank you. Pio Gerard, anything further?
Nope.
Thank you. I'm going to take a moment before I announce my recommendations. Mr. Perry, I have that you have been in the community, or you were discharged to special parole starting in May 2020. Since May 2020, this is your third parole violation. Prior to this violation, you had 2 criminal violations that resulted in new convictions. During this violation, you were in the community for about 3.5 months. And within that time frame, you received a number of PCS conducts and residential discipline reports for engaging in verbal altercations, leaving the halfway house without permission, and being unaccountable in the community. Taking into account all of what was said here today, including the new addendum, acknowledging that there was a nollie for an assault third, as well as your history and all the behaviors occurred during this during this violation, I recommend revoke and reparole on January 12th, 2026, which is an approximate 1-year sanction with the following conditions: no consumption of alcohol, anger management, no contact with co-defendant PB, a general no contact with victim MW, a general no contact with NA, mental health treatment, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on April 10th, 2025. So next Thursday, the board's going to say, look at your case. They can lower my recommended sanction, they can exceed my recommended sanction, or they can adopt my recommended sanction. Being that you're on supervision until May 2026, they have up until then, they could exceed it until your end of sentence. But again, on the 10th, the board's going to make their final decision, and you'll receive written notice of what their decision is. Okay, Mr. Perry?
So, Mr. Perry, hopefully the board will shorten this. It's up to the board to make a final decision. They're going to meet on April 10th. Give our office a call on April 11th, and we'll let you know what the board decided. Okay, sir?
Okay.
All right. Hang in there, okay? Take care.
Thank you.
And there you have it. And the parole board, they have only, I think, twice have not gone by the recommendation. So unless you see otherwise, assume that he is going to be getting out in January, which would give him another 4 or 5 months on special parole, which means that we might see him again before the next 12 months runs up, which is just crazy. You know what's interesting, though? I thought his attorney is so good. He says things so it's like he really understands each case. And I don't know, this is my takeaway. And even when I'm listening to him in his final statement there, I'm like, wow, yeah, he does have a point there. He's got his kids, he's got a significant other, he's got a boss that swears by him. He's playing semi-professional football for all these years. He's still on the team. There's consistency there. What's the big deal? So he didn't go to his work for a couple of times, and then you hear the parole where they're like, since you've got 2 new felonies, you've have assault, and it's like, oh my God. And then, and it's not even the maximum sanction. He's at the time of this hearing, April Fool's Day, April 1st, they're going to hold him for another 9 months, not even 8 months. And I'm still stuck on the fact that he's doing all this volunteering with kids and things like that. I mean, how is this your role model? But I mean, maybe who knows how much of it is actually accurate versus what's in a statement. But he seems to be someone who doesn't really know how to take accountability, how to do the right thing. He's not a child anymore. It's like, grow up, man. And don't get over the fact that in a carjacking, he pulled a gun out on someone and pulled the trigger. It didn't go boom. And because of that, he then got a gift he was charged with first-degree attempted murder. They dropped it to first-degree robbery and gave him that 9-year sentence. And then in 2019, cut 4 years off of that sentence, let him out, and he has not been able to stay out of trouble. And again, with this special parole thing, you kind of get a get out of jail free card, because the police just say, we're handing it over to you. And then these, this is also a data thing. Connecticut, they don't consider this as like recidivism or failed parole. They just, it's a sanction, it's some time off, but in their books, I'm pretty sure, I have nowhere to really say this for factually, I guess, without looking at the data, which who knows when they share it. I can't stand the data. You ever look at data reports for anything like large, and you try to find a report on it, anything that's like big, and it might be incarceration rates in some state, and the most available data is like always 2 years old, and it's like, why? Like, why is that acceptable? Why is that allowed? And probably because they spend like $30 million to some NGO or like whatever consulting firm to do this data, and it's like a contract. But you could just get the data. Like, we live in 2025. Data is data. It's so easy to just have data. There's no reason we should have data pools that are 2 years old where I have to buy a report to look at data that's. Anyways, I'm going on a tangent, but I lose my watching these hearings, these continuation hearings. Let me know if you want to see more of them. We have a lot. Now that we've been keeping track of these revocation hearings been doing it for over a year, we're seeing full cycle hearings. And we're the only channel on YouTube that actually puts in the work to do that, is because of Sir Richard's spreadsheets and Lady Holly's now, who's building on the spreadsheet and putting in all the research, that we're able to do this. And I guess to his credit, he didn't throw any baby tantrums at the end there. You kind of expected it the way it started. It almost ended a little bit anticlimactic, but there you have it. And with that, I'll let you go.
Yes, about the public defender. He hung up on me, ma'am. I wanted somebody else to represent me. I have a paid lawyer now that will represent me in this case.
Okay.
Oh, okay. So do you want?
What's your paid lawyer's last name, sir?
Man, I wrote it to them. I don't got nothing to say to you, sir.
So you don't wish to be represented by our office?
No.
Okay, thank you very much.